everybody. I'm Martha Minow, and it is my great pleasure to welcome and officially introduce Mary Bonauto. But I don't like where people are sitting because we have to go like this and this. So could people like move so that it's more in the center? Sorry to do that, but that would be really helpful. Thank you. So as you're moving, I get to say some great things about her. Mary is the Shikes Fellow in Civil Liberties and Civil Rights here at Harvard Law School, and that is a source of great delight for all of us. I'm going to say something she probably doesn't like. She's sometimes described as the Thurgood Marshall of the same-sex marriage movement. She didn't like that. But it's actually accurate, because it may seem to some of you that, wow, things are really happening and it's going so fast. For some people, it's been 10 years, 15 years, 20 years, 30 years working on this. And the person that I know who's made the most difference on this is Mary Bonauto. And she has, of course, been the strategist for the state court approach. We're going to talk about that together. She's also been incredibly effective at coordinating often not coordinated people. And so I'd like to talk about that too. And if we have time, I'd like to talk about comparative social movements, because Mary's also just a terrific student of, well, what's worked and what hasn't worked when you try to use law for social change. But most of all, what I want to do is make a lot of time for you all to have opportunities to ask questions and engage with her. But let's just start with, how did you start getting into this business? How did you get into this field?
Into law?
Yeah.
I got into law. I mean, sometimes I think it's because I had 3 brothers and I was the only girl and I had to make things right. But setting all that aside, I just, what can I say? Some people just have an underdog mentality. I do. These issues around justice and our nation's struggle around justice and making those promises, those bedrock promises, true for more and more people over time, are something that just really speaks to me and I care very deeply about. And then, of course, eventually coming out, which was not a good thing at the time that I did, and realizing that, boy, my life was going to be really different. My life might even really kind of be over. And realizing that, no, that wasn't true, and law was one way of making sure that my life wouldn't be over. I could either just suffer from the system or I could change the system. Decided to opt on the change the system side. And then I was very, very fortunate. I was a lawyer in private practice in Maine in the late 1980s. And in the late 1980s, HIV was really ravaging the gay community. I was a brand new lawyer. I volunteered to help. And that meant got a lot of requests to help. People who were suspected of being gay fired immediately. I got a lot of experience really fast. And so when Massachusetts became the second state in the nation in November 1989 to enact a non-discrimination law so that you couldn't fire people, discriminate in employment, housing, public accommodations, and credit, GLAAD, where I now work, Gay and Lesbian Advocates and Defenders, was going to hire its first ever lawyer to deal with sexual orientation issues. And I applied thinking I would never get this job. I was only 2.5 years out of law school. And I probably shouldn't have gotten the job, and I would never get it today. But I applied, and I got it. And I thought, I'll do this for 2 years. I'll be exhausted. I'll go back to private practice. And that was 25 years ago.
When there were some real setbacks at that time, there were some terrible court decisions. There were certainly backlash even when there was progress. How did you anticipate what the time frame would be for the work you were going to do? You thought initially you'd be there a couple years, but now what do you think?
Well, when I first got there, it's probably going to seem like an alien planet, but I will say, I was based here in Boston, and at that point, the overt violence against the LGBT community was rampant. And frankly, there were a lot of concerns that often police officials were directly involved in it, and sometimes there was evidence of that. And so it was just your basic physical safety, moving around, felt very compromised. And it was also true at that time, some of the public accommodations cases I brought actually involved people who were simply patronizing businesses, from used car salespeople to Dunkin' Donuts, who were then attacked because someone thought, usually correctly, that they were gay. It was that kind of environment. I know it's hard to imagine now, but that was true. And then, of course, when I started at GLAAD, it was just a few years after the United States Supreme Court had decided a case called Bowers versus Hardwick, which upheld states' power to criminalize what they call sodomy. And as a result, there was this sort of taint that came out of the Supreme Court across the nation, the idea that all gay people were criminal. And in fact, that was a question I was commonly asked at the time. And so there was this real sense of illegitimacy and stigma and fear. So from my perspective, part of what I wanted to do is try to get a handle on the violence, turn the tables, and say, hey, you should be prosecuting these crimes, not committing them. This is something that's serious. There were actually laws on the books that needed to be enforced, and try to get some of those laws enforced. And I brought a lot of employment discrimination cases, and initially no one would touch them. The idea was that it was some, this is a quote from a lawyer, like, this is way too militant. How can you expect me to do this? And really all I was asking to do was to partner with a more senior lawyer to enforce a duly enacted law of the Commonwealth. But eventually the private bar got it, that these cases were real, legitimate, and in fact, you could make money on them too. And that allowed us to transition, I think, into some other work, because as I was just saying to a gentleman before we started here, it was one thing to be able to just be able to move about safely, and then of course to have your job and hopefully not be terminated once somebody realized your sexual orientation, and eventually even to be out on your job. But then there was this other whole conversation that obviously needed to happen about, well, guess what? This person who you work with may go home at night and have a partner of 10 years, or may have kids. And guess what? They're legal strangers to their partner. They have no legal connection to them and no means for doing so. Likewise, unless they're the birth or adoptive parent, they're going to have no legal connection with their child. And that really, I think, re-inaugurated a different phase of our family law work. We'd already been doing cases where people had been challenged about their ability to maintain custody of their children when their sexual orientation was revealed, and so on. And anyway, we've just continued to build over time. And I remember, in the early 90s and so on, one of the things you would never talk about was marriage. Just don't talk about it, because if you say anything about marriage or suggest that anything that's going on might someday lead to marriage, forget it, you're not going to get it. And guess what? When you enact non-discrimination laws, it doesn't lead to marriage, in fact. But it's one of those sort of stepping stones that changes the discussion about what's right and what's wrong. Because law, of course, has enormous normative influence about what is permissible and what is not. So when you start saying that actually it's not okay to beat up the gay people, actually there are laws to prosecute people who do, actually you're not supposed to fire people simply because of who they are. You're supposed to judge how they're doing on their, on their jobs. And you start changing that normative discussion, it does eventually, pave the way for really full citizenship, and part of that's been marriage, but part of it's also been acknowledging, LGBT people in all walks of life, in all ages, and in every context.
Litigation is one of your major tools. How do you locate litigation amid all of the tools?
When I started at GLAAD, litigation was a primary tool, because for the most part, it's not like we weren't engaged in the legislative process, we were, but it was mostly defensive, trying to fend off bad laws. The idea of trying to enact protections was extremely difficult. That has changed. It's not like legislatures are eager to do all kinds of positive LGBT things. They're not. It's always a struggle, even today, even here in Massachusetts. But having said that, the legislative branch is more open, and so we do now much more effectively engage in litigation, in legislation with the executive branch, with agencies, and sometimes directly, over their heads, and then also, extremely importantly, with the court of public opinion. And I think to make lasting change in this country, you need to be engaged in each of those quarters. And the public opinion piece, never thought I'd end up here, but I just found myself inevitably just talking to people from all walks of life, obviously not just LGBT people, but trying to make the case for fairness in whatever context it was, in schools, and why schools should redress, completely hostile behavior to particular students rather than blame the students for being who they were. I just found myself having to really make the case for why something is right, almost regardless of whether something is legal or not. So I really think that's the key, is working in all four branches.
You described the early 90s. I remember very well being part of some conversations where people said, when marriage was the wrong thing to go for, big debates, big arguments within the movement. So how did marriage start to become a priority?
Marriage became a priority, and it was really, it became a priority from the ground up. And in my first week on the job at GLAAD in 1990, I received a call from a couple in Western Massachusetts who'd been together 10 years and wanted to get married. And there'd been a little bit of fanfare in the gay community that a lawyer had been hired at GLAAD. So they thought, okay, finally, somebody will deal with this for us. And I said no. And I said no so many times to so many people over the years because it didn't feel like the right time. I mean, I felt, you know, in 1990, on my first day on the job, I'm going to talk to police departments about how they're hunting down gay people to arrest. It didn't feel like the right time to bring forward a case on marriage. And so part of it is, I want to say that there's just been this steady drumbeat of what is really an understandable human aspiration for some people to want to have and participate in this enormous social and legal institution that really is, you know, imbued with values of love and commitment. I know people have their own marriages and their ideals are what they are, but it's a huge social and legal institution. And I will say that the government's exclusion of same-sex couples from marriage is a profound statement of disrespect that affects LGBT people in all walks of life. So I do feel like it has to be addressed on the human level and on the governmental level. But the other thing that happened was in 1993, the Hawaii Supreme Court issued a ruling that it looked to them like a trial court had erred in dismissing a case brought by 3 same-sex couples because they thought that there was sex discrimination involved. And they wanted to send the case back for a trial so that Hawaii could demonstrate its compelling interests in maintaining this discriminatory system.
Stop there 1 second. Let's everybody understand this. This was on sex discrimination. So the theory was?
The theory, it was a very formal theory that a man who wanted to marry a man could not, but could marry a woman. So his own choice of who he wanted to marry was constrained by his own sex. There's also, you know, this is a big part of what we do now, and I'm sorry I'm jumping ahead, but sex stereotyping and the idea that a man should only be attracted to a woman is a huge part of what we do in advancing sex and sexual orientation, sex, and gender identity cases now. But anyway, I'll bracket that. Anyway, what happened essentially was, I guess to not put too fine a point on it, all hell broke loose. And what I mean by that is there were enormous efforts in Hawaii to squelch this development. It took 3 years for the case actually to get to trial. In the meantime, the United States Congress passed very swiftly the Defense of Marriage Act.
Signed by President Clinton.
Signed by President Clinton, exactly. He even campaigned on it for a while until he was caught. And it had 2 parts, one of which, in my view, invited states to enact public policies against, quote, same-sex marriage, so that they would not have to respect marriages that were certified in some states. You know, if you went to Hawaii and got married and came home, and your state passed one of these public policies, then your state would be free to disregard your marriage as essentially a nullity. And the other piece is the piece that was struck down in Windsor, Section 3 of the Defense of Marriage Act, which said that for all purposes, under federal law, marriage is only a union of a man and a woman, and therefore the federal government would disrespect marriages of same-sex couples once they came to fruition. Of course, the Congress thought having followed this all really closely, the Congress really thought that by passing this law, no state would ever allow marriage for same-sex couples. Thankfully, they were wrong. But anyway, so all hell broke loose. But I will say this, that Hawaii was incredibly productive, even though ultimately the Hawaii Constitution was amended so that only the legislature could, quote unquote, change the definition of marriage. But nonetheless, there was just so much awakening to people's aspirations that they wanted this. They wanted to have this choice. Many people wanted to marry, and even some people who didn't want to marry felt like we deserved to have the same freedom of choice to decide whether to marry or not. And we brought litigation in Vermont. GLAAD, where I works in the 6 New England states. We were looking at state constitutions. We were looking very carefully at courts. We were looking very carefully at state legislatures, and for a variety of reasons, really principally having to do with the legislature and the amendment process. You know, if you were to win, what would happen politically, would there be an amendment as there had been in Hawaii, we decided to go to Vermont first. And in 1999, the Vermont Supreme Court did something that seemed amazing at the time, and it was, which was to say that same-sex couples should have all the same rights and protections under state law that are conferred by marriage as anyone else, and called this a recognition of our common humanity. And then, sort of, can I just say, like, everything broke loose in Vermont as well. But essentially, the legislature, which was then tasked with implementing the ruling, came forward with this idea of civil unions. We worked very closely with them. My co-counsel in Vermont worked very closely with them, Beth Robinson and Susan Murray. And they were incredibly gutsy, I have to tell you. I mean, there were people who came out as gay in this process. There were people who came out about gay family members. There was this real sense of vulnerability up there. I mean, it was extremely intense. There were people who were, big Operation Rescue, anti-abortion people who would stalk folks in the hall. It was very, very tense. But ultimately, they passed the civil union law, and people started joining in civil union in July of 2000. Big legislative backlash, absolutely. Democrats lost control of the House, not the Senate. And I think that really terrified Democrats around the nation for a while, so we didn't really have a lot of political supporters. But actually, after all was said and done, and things really did settle down to some degree in Vermont, and we started moving forward on a positive trajectory again there. I lived in Massachusetts at the time. I now live in Maine. But I really couldn't go to the grocery store without somebody approaching me about this issue. Like, if they can do this in Vermont, why can't we do this in Massachusetts? And I have to say, I agreed. And Chief Justice Marshall is here, and she's written very eloquently about the Adams Constitution here in Massachusetts. And what can I say? I'm a fan as well. And I really did believe that Massachusetts would be the place to break that historic barrier. And so we again, suffice it to say, we had no shortage of people who wanted to serve as plaintiffs in a case. And sometimes that's a red flag. Like, you're too eager to participate as a plaintiff. It's a lot of work to be a plaintiff. You're there as an ambassador for a larger community, not just to sort of talk about your own personal predilections about things. But in any event, we spent a very long time constructing a case and filed a case under the Massachusetts Constitution in April 2001. And on November 18th, 2003, the Supreme Judicial Court, in an opinion by Justice Marshall, broke that historic barrier and has really become a marker by which all future efforts to look at equality for LGBT people has been judged. And that, I have to say, that decision and people marrying in Massachusetts is what really changed everything. The principle is right, and then people seeing the reality of what it looks like when same-sex couples marry. A lot of happiness. It's hard to argue with it. So anyway, that's part of how we got there.
So Massachusetts was the right place to bring the suit, in part because of the tradition, our constitutional tradition, partly because of the public attitudes, but also partly because of the structure of the state constitution. So why was that?
That's exactly right. I mean, Massachusetts is one of very few states that has an incredibly rigorous process for amending the state constitution. So there are two ways to amend the Constitution of Massachusetts. One is for a legislator to bring forward, to bring forward a amendment, in which case the amendment has to be approved by a majority of two successive legislatures. So there needs to be an intervening election. And a lot can happen in the course of an intervening election. So that's one part of it. And then there's also a process for a citizen to initiate a change to the Constitution. And the scary thing about that is that it takes only 25% of the legislature in two separate legislative sessions to approve of it. And when we happen to know, we pay attention to our opponents. It's always a good thing to do. So paying attention to our opponents, we were aware of the fact that they were still really upset about Vermont, and they were going to move forward with a constitutional amendment here. And I felt like there's no way we're going to have a vote on a constitutional amendment here without trying to win first. And again, we were already moving forward with litigation, thinking about litigation anyway. So eventually what happened is the decision comes down. There's already an existing legislative amendment being considered in the Massachusetts legislature. So we win in November. There's an attempt in Massachusetts. I hope this doesn't make Justice Marshall uncomfortable, but my perspective is what happens is that members of the legislature who were really upset about the decision and felt like they should control this issue put forward an advisory question. They put together a civil union bill and say, won't this pass constitutional muster? And of course, it's civil unions with a marriage ban in it. And the Supreme Judicial Court, issues advisory opinion saying, no, this doesn't satisfy the constitutional mandate of Goodridge, which is about equality. This just, reinforces the constitutional infirmity that we were addressing in the first place. Well, I will say that decision comes down, and the next day is the first day of the Constitutional Convention. And the tempers were high. They were high. Who are they to tell us? We're the legislature, et cetera. So it was a very hot time, but I will tell you, it's been incredible. It's been incredible to see the power of a court being so clear about principle. Because what happened and continued to build is after that decision, and then after the follow-on decision in the opinions of the justices saying, no, civil unions are not enough, it's unequal, was that more and more people began to rally to our side. And I will tell you, I will never forget this, but there was a legislator who was a senator, a Democratic senator named Marianne Walsh, who was basically on the other side of everything I'd ever done to that point. And she stood up in the convention and said, this decision is so beyond my comfort level. But I have read it. I have read the Massachusetts Constitution, and this decision is correct. And my comfort zone is not the measure of my constituents' constitutional rights. And time and again, people rose to principle. And then, of course, once people started marrying in May, people were also able to just rally around the reality. I have to tell you, at the time, there was a lot of Armageddonish kind of discussion, what was going to happen on that day when marriages started. But then, of course, what happened? It was a really nice day. So I think that reality and the fear going away also helped. And again, the joy really spread through the land. And it was just unfortunate for a while that this was a self-contained experiment in Massachusetts because Governor Romney had erected some barriers around the state so people from out of state mostly couldn't marry. But eventually that all changed. And once the secret of Massachusetts has now become known through the land.
The midnight weddings started, the joy, the sharing, but also I again want to say that this constitutional structure, the speed bumps helped, so that there were a lot of people who got married. And I think it would be hard to live in Massachusetts and not know somebody who had gotten married under Goodridge by the time that it was plausible to imagine legislative change.
That's exactly right. And just tell me if this is too wonky,
No,
okay?
Please.
So what eventually happened, when the Constitutional Convention sessions commenced in February of 2004, our opponents were very confident we'd be dead by, in an hour. They would have passed something, would have been the first time there had been a passage, we'd have the intervening election in 2004, and then in 2005, that would be it. We were alive at midnight. We were alive for several days before they finally agreed to put civil unions in the Constitution with a marriage ban. That was the amendment that passed in the first round. Well, by the time we got to 2005 and the legislature took this issue up again after the intervening 2004 elections, the Republican sponsor of that amendment stood up to say, I withdraw my support for my own amendment because we've all seen now what this looks like. Yeah. And there's no reason to be afraid.
It's amazing,
yes.
Absolutely amazing. I'm going to open it up in a minute, so think about your questions that you want to ask. Some people say this has been the fastest successful social change effort using the courts in American history. A, is that true? B, how would you assess what made this happen?
In terms of whether it's true, every sort of group that has been stigmatized or whatever has its own unique history. So I will just say, in terms of when you count, where do you begin counting? Even in my own life, I know plenty of people who did not live long enough to see what we have today. There's a whole pre-Stonewall history of people who had lives that were squelched by official government discrimination. And on marriage itself, there were people who were really inspired by the US Supreme Court decision in Loving versus Virginia in 1967. And it's, justifiable statements about this is a, fundamental liberty for all Americans, and felt like we are among the all Americans here, and then had their cases treated very dismissively by state courts. And the Supreme Court dismissing a case from a couple in Minnesota for want of any substantial federal question in 1972. So anyway, I think you have to sort of count back a ways. And I think what happened on the marriage issue and on a lot of issues is that there was a sense that this is just not possible and we shouldn't even bother to want it. But when it comes to marriage, there were always some people who wanted it, and it took something like Hawaii to make people feel again like it's okay to want it again. And even though people thought we were nuts for the kind of work we were doing, I will say that Vermont, even though it didn't achieve what we had hoped it would achieve, gave people the confidence that we could win something. And we also, in Vermont, by the way, withstood constitutional amendment attempts. Yes. And there it takes 3/4 of the Senate to approve of an amendment before it can go forward. So it's a little more, even more rigorous than Massachusetts. And again, it has to go twice. So anyway, so it depends on when you count.
I think that's just such an important point. And certainly the family law casebooks include cases from the 70s. People went to court trying to get a marriage license, being denied by the clerk, being told you don't fit the definition of marriage in this dictionary. So people have been trying for a long, long time. And marriage, of course, is just, as you say, one piece of a much larger social movement that's been, oftentimes fighting just for safety.
Exactly. And if you look around today, I will just say very quickly that there are 29 states that don't have any sort of non-discrimination law for sexual orientation and gender identity. Now, again, you can try to use sex to achieve gender identity protections, and so on. I get that. That's great. But there's no explicit law. And there's no law at the federal level. And you know what? There isn't going to be one for some time.
So employment discrimination, where you started, is still a problem.
Exactly. And now, of course, we're in this incredibly ironic position where people are marrying in states where they have no protection from discrimination, some of whom are losing their jobs.
Right.
Yeah.
So I'm going to open it up, but as you come up and ask a question, I'm going to ask you, the Supreme Court had the opportunity, of course, to take up this question again recently and didn't. And how should we read that?
I think we should read it as we're going to win. At least that's what I hope. Yeah, I don't know how you put the toothpaste back in the tube, and marriage is not just, marriage is a far-reaching legal status that transforms you as an individual in relation to others, in relation to the state, and I don't know how you could just suddenly decide to unmarry people. And I think if they really thought there was something wrong here, they would have stopped it. I mean, I have a lot of theories about what might have been going on. As you know, so far, post-Windsor, we have been winning marriage cases with, very few exceptions, District of Puerto Rico, District of Louisiana, and one state court case. But, we're talking dozens of wins at this point, winning in the 10th Circuit and the 4th Circuit and the 7th Circuit.
Amazing places.
It's pretty incredible stuff. So I think it's that we win, and they're waiting for a conflict to arise.
So say who you are.
Hi, my name is Yassine Aldiq. I'm a second-year student here at HLS, and I wanted to ask you a question. It was really interesting to hear that you kind of began this movement, or at least started to initiate or instigate progress at a time when individuals were being fired for being members of the LGBT community. And now, while at Harvard Law School, we see so many of our employers celebrating this specific niche at the law school and catering to the individual needs of LGBTQ students kind of in the workplace. So it was just kind of interesting to think that now I live in this world because of the work that you've done. And so I wanted to just ask you a quick question about kind of finding pride for yourself to advocate for this movement at a time when it really felt dangerous to speak up about who you were and the group of people that you wanted to fight for. Because there is a battle within as we move forward to create movements for social change. And so how do we navigate our own identities as we try to speak on behalf of others? It's
a great question. You know, I've been in the fortunate position of the discrimination that LGBT people face is a discrimination that I have faced. And so there's a definite alignment there. And, you know, I think a lot of people would not have taken on the jobs that I took on. And I was told at the time that I took the job at GLAAD that I was throwing away my career. It was going to mark me forever. And I felt that it was important. And I will also say this, like, why did I have the nerve to do this? I don't know. But I did have the nerve to do this. Is it because my parents loved me? I mean, I really don't know. But I did really feel very, very deeply that this was wrong. And the person that people had loved before was the same person I was now. And I needed to make people see that. And I will tell you, I mean, I don't want to go on about this, but you know, I had plenty of problems related to my own sexual orientation, including people trying to burn down the house I lived in when I was in Boston in law school. And at the time, it was inconceivable to me that I would ever go to the authorities about that. It was something we were able to take care of internally. You know, it was at the back door, you know, had a fire extinguisher. But it was just inconceivable to ask for help. So I will just say that I have just, you know, I understood how important this was and how, what really seemed to me just off kilter it was, and that there were ways to find common ground.
Can you say a word about the campaign in Maine? Because say a word about that.
Okay. Well, perspective one on Maine is, you know, as you know, we won in court here in Massachusetts on the marriage issue, and winning in court just rekindled what's been a 200-year discussion about who should be in charge, the courts or the people, forgetting that the people, of course, authorize the courts to play the role that they play. And so anyway, in the whole narrative and the arc of the marriage work, it was important also to win in legislatures. We started winning in legislatures here in New England, in New Hampshire and Maine, Maine, and Vermont in 2009. It was very important to get there. And then in Maine, we were forced to go to the ballot, and we lost narrowly, just as they had lost in California, same kind of campaign. And in Maine, the only way to move forward again would be to put ourselves on the ballot, to initiate a law, to say, please let us marry. Okay, now I'm going to say something. I am not a huge fan of the citizen initiative process. I'm not a big fan of direct democracy. Perhaps that is elitist on my part, sorry. But I know it started as this whole progressive thing, and I feel like it's been completely contorted by money and other interests. Anyway, so the whole idea of putting myself on the ballot was really loathsome, but we also realized it was the only way forward, so we did. And how do you win? If you put yourself on the ballot, you've got to talk to a lot of people. Now, we had been talking to people, but we really had to ramp it up. And so, thankfully, there were many, many people, gay and non-gay, throughout the state, who were willing to really, truly engage their neighbors and go out in their communities in all kinds of weather for years and have genuine conversations about what does marriage mean to you and to me, and to find common ground. So this was not coming out stories in the sense of, let me tell you I'm gay and this is why you should support me. It was really trying to find common ground about marriage. And our ads were to that effect that we ran, you know, where we had, like, our first ad was a Mainer who lives in Machias, Maine, which is extremely remote. You're really tough if you live there. He was a World War II pilot. And he was sitting around a table with 4 generations of his family. And he was talking about what he fought for and why he wanted his granddaughter Katie to be able to get married to. And the ads were of that nature, and we didn't script them. They were Mainers who you would not necessarily expect to be with us, who were with us. And it gave people permission to sort of rethink their previous opposition. And just as President Obama, I think extremely importantly, came out in support of marriage and talked about his own journey of understanding he'd been opposed, but he knew friends, his daughters have friends, and he's thought about the golden rule and how would I want to be treated, and this is the government. That kind of thing has given people permission to sort of rethink their previous opposition. And this isn't a completely accurate, up-to-date statistic, but as of about a year ago, 14% of Americans had changed their minds on this issue, which is phenomenal.
Yeah.
In a very short amount of time. So anyway, in Maine, we went through this whole experience of truly, very deliberately trying to find common ground and listening, not just talking. And I have to say, I think it's just such an important lesson for all legal and social justice movements is how to make sure we're always integrating all of those elements, including that one.
Great.
Hello, I'm Mituel. My name is Mal Albuquerque, and my question stems actually from a recent interaction I had with a same-sex couple that were living in Israel and moved to the States after DOMA was struck down. One was a U.S. citizen and one wasn't. So I was wondering, like, all the issues and everything that we're dealing with here domestically, how do you see it being perceived globally, and what effect is it having internationally? Not only on U.S. citizens living internationally, but everyone in general.
So as a general matter, what is happening here? How is it being received internationally? Well, what do you think about how it's being received internationally?
I actually have never considered the issue until I met the couple.
Yeah.
I've never considered that it's had an impact outside of this, because you read the New York Times, the Wall Street Journal, you only see what's happening in the States. So.
Right.
There's also the reverse, which is how have the developments in other countries affected what's gone on here?
True. You want to talk about that?
Well, you know, I'll just say two things. You know so much more about it than I do, but interestingly, the United States started to have state decisions and practices approving adoption and foster care by same-sex couples at a time that it was not allowed, particularly in Scandinavia, where Scandinavia was moving ahead on marriage or civil union or something like that. And so the comparison between the two, I think, was very, very striking.
Exactly. Now, I can't globalize about the reactions elsewhere, but I will say certainly there's been an effect of inspiring some people. And so I have been, over the years, connected with people from Canada, from Ireland, from various other countries who look to our work as some sort of model, and to what degree can it map on. But I will also say that clearly there's some opposition out there, and this is actually findable, and you can see it on the web for yourself. But some of the opponents that we have faced here of the right-wing organizations, like the National Organization for Marriage, have really taken their campaign international, and are a big source and a big source of the of various countries rallying against us now, including they were in Russia recently at this family conference where they were again trying to inaugurate a whole new series of anti-gay laws. So the movement's been internationalized in both respects. Our opponents are out and about, and I haven't at this point had a lot of time to go work on other countries' laws or anything, but clearly we try to share to the extent we can.
Sure. Say who you are.
My name is Sam Riel. I had a question about the relationship between impact litigation and low-income LGBTQ populations. So I was thinking that many of the impact projects that organizations like GLAAD and Land Illegal take up are ones that have benefited people who already have the means to take care of themselves, and it was just the LGBTQ piece that was, making lives difficult for them. So, when you pass marriage, you're benefiting people who are already in the position to get married. When you pass even anti-discrimination laws, you're benefiting people who are not perpetually unemployed or unemployable. And I was wondering if you think there's something inherent about impact litigation that, at least heretofore, has but has had a disproportional benefit for wealthy people, and if there's something that we can change about the impact projects we take on now to benefit low-income LGBT populations.
Yeah, thank you for the question. And it's something actually we are thinking about a lot. So I guess one area where we may not share the same perspective is like when I look at marriage, you're right, it's for people who are eligible to marry, so they are in a couple and they're not already married and whatever. So yes, that's true. But I know that affects people from all walks of life, without a doubt. And the protections it provides are extremely valuable. So I think there's ways in which impact litigation does affect enormous swaths of people. When you look at employment discrimination too, and I think about the people who I've represented, it's not only executives. I mean, it's people who are minimum wage workers, part-time cashiers at a store and so on. And it matters as much for them as anyone else. But having said all of that and pushed back about the framing of the question a little bit, I will say to you that one of my big concerns going forward, and I was saying this to the dean just beforehand, is people are very excited about the marriage work. okay? And I'm partly responsible for people being excited about it. So I'm excited, okay? But I realize it's so not everything. And I am so concerned about people saying, I got my marriage, we're done with DOMA, we can get off the field. And I feel very much, and this gets in part into the comparative movement piece, is how do we now do even a much deeper dive to think about the kinds of issues that you are raising to make sure that we don't re-instantiate somehow, barriers, discrimination norms or whatever, and we really dig much more deeply to deal with the economic justice issues, the trans youth, the homeless LGBT kids as a general matter, on and on. So if anything, I feel like part of what we're going to do, and already are doing actually, is doubling back for different rounds and more strategic employment litigation in particular industries and with particular workers and so on. So anyway, I hear you. And I think impact litigation is not everything, but I also really believe, as I look at other movements and the amount of pushback that other movements inevitably got, they achieved signal victories, but their opponents had not gone away and were in this for the long haul and have been able to erode so much that I don't want that to happen here either. And I think it has to do with even deeper cultural engagement with all aspects of the LGBTQ&I communities.
Hi, my name is Shane. I'm a 3L. My question is, I guess, somewhat related to what you've been talking about this whole time, and it's backlash theory. And I'm really curious about bringing in the comparative element. If you read Michael Klarman's book on this, he still uses a backlash frame to say, see, courts decided things, people hate when courts decide things, bad for social movements. But in the sense that book has been written, the LGBT movement now seems to be the prime counterexample of what backlash theory doesn't actually happen. And I'm curious, was the LGBT movement different from your perspective from other social movements, whether it be abortion rights or whether it be death penalty are kind of the two that I've heard most talked about? And if it was different in a backlash sense, why?
Yeah, I think those are great questions, and I can't answer them. Sorry. It's the kind of thing I actually really want to spend more time thinking about, to tell you the truth, because my suspicion is, with all respect to Professor Klarman and recognizing that there are backlashes that happen, is part of the issue is how do you also respond to those backlash, and do you have the resources to respond to the backlash and enough creative tools to respond to the backlash? So I don't think. I suspect it has to do in large part with people pulling away from movements after victories are achieved. And one of the things that when I look at some of the other movements out there and I see how people get on the defense about particular issues and the movement becomes defined by just a couple of issues, I'm really determined that the LGBT movement not become defined by just a couple of issues, but continue to reach out to people in many different spectrums and whatever, and to continue the cultural engagement. So anyway, I guess my thought is, I don't feel like it's so much as backlash as do we maintain the empathy and the commitment of people who brought us to where we got as the battles get different and harder and the right wing plays the long waiting game. Does that make any sense? Okay.
Great.
Hi, my name is Susan. I'm an LLM from Uganda. And I'm just curious whether there are any principles, any universal principles that you would say have helped the movement here to go to the point where it is, and if those can be applied elsewhere. And also if there is any sense of responsibility to maybe a global perspective, because I know that in my country, discussions of LGBTI issues are based on, oh my God, look at those people, they're now getting married. Don't allow these people a right to privacy, because very soon it's going to look like that, like a right to marriage. I know that that shouldn't be a limitation to the kind of advocacy that needs to be done here at home and protections for LGBTI people in the US, but is there a kind of global responsibility to say, hey, we're doing this and it's really good here, but the perspectives we take need to also consider what's happening around us? Thank you.
Yeah.
Boy.
It's a really challenging question. Even setting aside Uganda, one of the questions that I would receive about Massachusetts was, don't you understand that what you're doing in Vermont and Massachusetts is unleashing this ferocious firestorm in other states that are now not only passing statutes but locking down their constitutions to make sure there's no protection for same-sex families at all. And haven't you harmed us? It's part of the whole backlash thesis. And it's one thing to think about that in the US. Internationally, much more challenging. And I guess I'd have to also ask, like, are we better off not doing this? I don't think so. Are we better off having some broader discussion about human rights? It's not led by people like me. In terms of your country, I don't know a lot about your country, but we have just represented somebody from your country and achieved asylum for him. And he, John Wamberry, appears to be part of a very vibrant group of people locally.
Courageous.
Yes, very courageous, who have been bringing these issues to the fore. And I have to say, when I think about, it's not comparable exactly, but I will say that, there were plenty of times here when people were at great risk for speaking out at all. The reason my organization was founded in 1978 was because gay men who would congregate at the Boston Public Library were being arrested for congregating. Okay, that's in Boston in 1978. So I get that there are risks involved, and I guess I'm hoping that we're all on different trajectories, but that eventually the utter humanity and goodness of what we're talking about here, people being who they are, being authentic about who they are, and wanting to contribute their full selves to their community, is ultimately going to carry the day. But I totally get it's a long timeline.
My name's Alex Chen, and I'm a 3L. Thank you so much for being here today.
Sure.
I guess my question is related a little bit to some of the questions that have come up before. I'm curious, we look at marriage now, and I think there are a lot of people who say it was inevitable that it would happen, that it's kind of a fait accompli. Like, once something has happened, it's kind of very hard to walk back and say it wasn't inevitable that this was going to happen. It wasn't just a matter of natural justice. So I'm curious, and there are people who say that part of the reason that marriage was easy to accomplish comparatively, right? Right.
It didn't feel easy along the way.
It was really
they
easy,
say it's
right?
because the U.S. is better at recognizing social rights than economic rights, or social issues rather than economic issues. And I'm curious to hear what you think about that. Do you think that there is something distinctive about marriage, about it being a social institution, that made these arguments more legible or literate to people in the U.S. and whether that means that it'll be harder to make other types of arguments going forward to do with LGBT rights, things like economic discrimination, employment discrimination, and do you think that there are lessons that we can take from that marriage battle? There are ways that we can make that message that you've learned from all of your decades doing this work.
Okay, that was a lot of questions. But a lot of really good questions in there. It's interesting about the economic rights, social rights comparison. I'm just going to say, just to be really clear, getting to marriage is not easy, okay? And I can say why. And when it wasn't inevitable, and I just want to say one thing about the inevitability piece. So it is true that in 2005 in Massachusetts, the Senate Republican sponsor of this amendment withdrew his support, but a citizen-initiated amendment followed. And the citizen-initiated amendment passed the first round. And so everything was hinging on this second constitutional convention in June of 2007. And again, they needed 25% support. And I can't tell you how much was unleashed to try to keep that amendment from passing. And it was defeated, which was incredible. And it's only then, really, that we hit this turning point, I think, of saying, okay, it's really secure in one state, and you can't make that one state go away. And then in 2008, we saw 2 more states. And then in 2009, we had the legislative victories, and it's just been building out since then. But I want to tell you that had we lost this in Massachusetts, I don't know that I'd be sitting here talking to you about marriage today. I really don't. Anyway, on the economic rights piece, I will just say marriage is an institution and a shared experience in this nation, and I think that makes an enormous difference once people could get over that it was gay people who were talking about marriage, that gay people might want to marry, because that was why would you want to marry? Why would you want to marry? And so on. But yes, it eventually tied into this whole huge reservoir of experiences and warm feelings associated with the institution. And I will say this, in contrast to 10 years ago, there are many Americans who believe discrimination against gay people is wrong. Now that belief is about this deep, but nonetheless, it's a helpful building block for moving forward. And so in that respect, in that respect, we have some advantage, I think, in moving forward on other issues like non-discrimination. But when you start talking about economic rights and so on, like making sure that every single person has means, to feed themselves and housing and shelter. I mean, it's, you know where we are as a nation on those issues? Nowhere, nowhere in terms of constitutional law. And so I just view marriage and access to an existing institution as something entirely different from that other whole substantive set of issues that I think perhaps tie into more economic rights.
But let's recall that loving wasn't until 1967.
That's right.
And the Supreme Court ducked several times the opportunity to address racial barriers to interracial marriage. And it looks maybe to you like that was inevitable. It was not inevitable. We were very lucky to be able to screen a movie about the Loving case last year, and Mrs. Loving actually agreed to the making of the movie in part because she really wanted to be helpful to the same-sex marriage movement. And so the relationship between the movements is itself a really interesting story.
Hi, I'm Mirav, and I'm an LLM from Israel, and I was interested in two things. First, you mentioned that after the success of the same-sex marriage movement, there is a question of how do we proceed from here. So you mentioned the homeless children and work discrimination, but I was wondering what are the current most burning challenges for the LGBT equal rights movement as you perceive them? And do you think that it's strategically wise for the LGBT movement to unite forces with the feminist movement? Do you think it makes sense to see sexual orientation discrimination as a form of sex discrimination, as you mentioned earlier?
Okay. Well, taking the latter point first, there are attempts now to rewrite the whole federal, what was called ENDA, Employment Non-Discrimination Act, but to basically make it a much broader law that would address public accommodations and housing, which I support. And at the same time, to continue enumerating, where sex is enumerated as a protected characteristic, to also include sexual orientation and gender identity. At the same time that in litigation,
Right.
we are pursuing the tactic, quite rightly, of saying, well, sexual orientation and gender identity are a species of sex discrimination. There's nothing that forecloses us from making both arguments. Enumeration, as the Supreme Court has put it, is an essential device for conveying what a law encompasses. It's not intuitive to everyone that sex includes sexual orientation and gender identity. So we are proceeding on both tracks. And frankly, that unity has been in place for a long time. So it's not a question really of joining forces. Women's groups are actually at the table too, in terms of, do you amend Title IX? And do you open that up, since there's so many people who want to create possibilities for more money for football teams? Maybe you don't open up Title IX, but you address other, you figure out other ways to provide protections based on sexual orientation and gender identity. So anyway, that's already happening. And then the first part of your question was, what do I see as some of the big priorities? One of the big priorities I see is that is around young people. And I mentioned that here in Boston, 40% of the homeless youth are LGBT. And most of them are homeless because they have been forced out of their own families and harassment at school. So what is it, I'm a parent, so what is it that convinces a parent that the best thing is to have their child leave their own home? It tells me we have a lot of work to do on attitudes. When I think about attitudes, I think about things like, okay, what are the cultural institutions that shape attitudes? And there are many of them. There's the military, there's the workforce, there's also school. And I have long been a proponent of trying to think about more inclusive curricula, and to do it, of course, in a community-based setting, in a consensual way, to think about what really makes sense in terms of teaching this next generation. And even the battles that would inevitably flow from that kind of discussion are educational in and of themselves. And some would be lost, but many would be won. So that's just one example. Of course, we're also dealing with really vulnerable youth who are in state care. I just had a conversation recently with somebody who works with foster parents who said, guess what? Foster parents are not equipped, even here in Massachusetts, to deal with LGBT kids. They say, we don't know what to do. So there are a lot of kids who are being lost. And I view that as something that has to be addressed, because I guess my bottom line is your sexual orientation, your gender identity, your race, your gender, they shouldn't matter. It shouldn't matter in terms of your freedoms and your opportunities in life. And when they do, we have to do something about that so that they don't. Because the goal is to make sure that people are contributing what they can contribute from their authentic selves, and not spending all their time fighting discrimination. So anyway, I view that as a huge priority. I would like this generation to end HIV. I think that would be great, and it's doable. Because again, we're losing, well, I shouldn't say losing, but there are about 1,100 people between the ages of 13 and 24 per month who are seroconverting to HIV. And many are youth of color. I think that has to stop. I view employment discrimination as a huge problem, and I say that because, I say that for a number of reasons, but one is this. Consider the wage gaps that exist between LGBT people and others. They are profound and stark. And it's, and since gay people are spread out throughout the workforce, what accounts for all of this disparity? Some of it clearly has to be discrimination, and I am perfectly well aware of discrimination that exists. And the other piece that I would say is, to the extent there is any perception that gay people are white, and only white, well, obviously that has to change. And we are very excited about, and we've always had plaintiffs from different walks of life, but really excited about featuring that many more people from, different races and different cultures and so on in the litigation that we do. So anyway, I see those as some of the priorities.
I think we really do need to end, and I want to actually give everyone a chance to say thank you so much to Mary Bonauto.
Thank you.